Welcome to the Family Law Channel. The Supreme Court this week issued a decision limiting the circumstances in which prisoners must be told of their rights before they are questioned. The question in the case concerning prisoners Howes versus Fields was whether an inmate's confession to a sex crime should have been suppressed because he did not receive the familiar warnings required by Miranda v. Arizona. My guest is Judge Eugene Hyman, retired Superior Court, Santa Clara, California, the host of FLC. Judge Hyman, welcome back.
Thank you.
They're sort of tweaking Miranda here a little bit. Can you explain what this ruling really means?
Sure. There's some subtleties here. One, pro and con, is the fact that he was in custody. The majority said, well, he's in a different environment than if he had been taken off the street or had been somehow not free to go, because the reality is that he isn't free to go. What he was capable of doing, the majority said, is if he didn't want to talk, he could have said, take me back to my cell. And he didn't do that. And they found that a person in a prison or county lockup situation is less likely to be intimidated than a common citizen is. The minority took issue with that and said that, hey, given that it was police officers, given apparently it was taped, recorded, so they could tell that the officers were being rather hard on the defendant in terms of yelling at him and things of that nature. And they thought that he was more vulnerable in that kind of a situation, but the majority felt otherwise, and therefore the legal principle. Miranda is one of those things that has been attacked by conservatives over the years that think it's a bad decision. My experience as a police officer, as a criminal defense attorney, and as a judge is that for the most part, the majority of people that are advised of Miranda waive Miranda, and which is kind of surprising. You would think that once you're advised that you don't have to talk, but a lot of times criminals think that they can talk their way out of something, or that it's to their advantage to make a statement when asked, because they'll be able to say, well, gee, I wasn't evasive. When the cops asked questions, I answered them. But my experience has been they outsmart themselves. They should avail themselves of Miranda, but they don't. In this particular case, the majority said you are already in custody. It's a less threatening environment. You're not going to go free, and you have the option. You had the option to say, I'm going back to my cell, and you were not required to be admonished of Miranda, and you were not required to waive it in order to have the statements that you gave become admissible in your subsequent criminal action.
Talk about, to the casual observer about what the realities of Miranda are right now. Now, someone gets their rights. How does law enforcement, find out if these people really understand what they're saying here? Because it's a stressful situation. How sure does law enforcement have to be that these people understand that they don't have to speak?
Well, they actually don't. It's the reasonable person standard. Right. And when the reviewing court, whether it be a trial court or an appellate court, say, hey, what would a reasonable person interpret this to mean? Now, Miranda has been modified over the years. Many, many years ago, when you gave Miranda, you had to say, do you understand this right? Do you give up this right? Now what you do is you advise the person of Miranda. You just say, do you understand? And then you just begin asking questions. You don't have to get a specific affirmative reply that you're giving up these rights. It's assumed that if you answer questions that you're asked, that you are giving up your rights. Now, the other interesting thing is that now some states require that if you're underage that you have the right to have a parent present. Now, not all states require that. California doesn't require that. There's been California decisions having to deal with a situation where a kid's in custody and they ask for their parent, and then the question is asking for a parent the equivalent of asking for a lawyer? And the case law has held that it is not. You have to specifically ask for a lawyer. Now, each particular case is potentially unique. In each particular case, you might have a situation where there might be an exception. But, if the person is obviously mentally impaired, then you have an argument whether or not they were capable actually of understanding and waiving. But it would have to be something that would really be obvious.
And finally, given the proliferation now of these recent exonerations in places like Texas, and it's leading all of us to believe that there is a significant amount of those who are prosecuted and found guilty who actually are innocent of crimes, but find themselves in a situation in interrogation where for some reason or another they either confess or they implicate themselves for some reason, and here Miranda's given and they understand that, but still these kinds of things can happen.
Absolutely. But that's why there's a requirement that you can't be convicted based upon your statements alone. There has to be what's referred to as a corpus.
Right.
So if I said I killed JFK, there still has to be some reasonable evidence demonstrating that fact. I can't be convicted of that crime just based upon my own statements for that very reason.
Well, Judge Hyman, always a pleasure. This is, I guess, an indication that the court appears to be not shying away from these big issues, is it?
Correct.
And you kind of like that, don't you, being a judge, right?
Well, I mean, that's what they're there for. There's a reluctance on the part of all courts to address issues that are not squarely before them, and this was an issue that is squarely before them. And they've had numerous Miranda issues. If you specifically have not waived Miranda, and then the police come back and want to question you later, and they give you Miranda again, if you waive it a second time, case law seems to suggest that you have to initiate the request for the police to come back. You can't have a situation where the police are constantly coming back, re-Mirandizing with the hope that you're going to waive it based upon subsequent actions. Now, the other thing that's interesting with respect to Miranda cases has to do with the situation where the police intentionally didn't Mirandize, then question and get all kinds of statements with the intention they can't use the statements in the case in chief, but they can use them for purposes of cross-examination or impeachment should you decide to testify. And basically what the courts have said is that if they can demonstrate this was a process, an embedded process within the institution to do so, then the court might not allow them to use those statements for purposes of impeachment. But thus far, they haven't found an invidious teaching or purpose in terms of these kinds of things. It's been on a case-by-case basis, and they've been allowing the impeachment. But I think that they found that this was taught in the academy as a practice or a procedure, I think you would see a different outcome.
All right, Judge Hyman, thank you.
Thank you.
You can find Judge Hyman as the regular host of the Family Law Channel, and you're watching FLC here on the Legal Broadcast Network.